Accidents involving drunk drivers are actually treated differently under the law in the state of Oregon. Your injury claim against a drunk is the same as whether he was drunk or not. You're entitled to compensation for your medical expenses, your wage loss, for pain and suffering, for how the injuries are going to interfere with your life. You're also entitled to make a claim against the drunk driver for punitive damages. And punitive damages are not designed to compensate you for anything you've gone through. They're designed to punish the drunk driver and send a message to other drunk drivers that you shouldn't do this in the state of Oregon. What we found, though, with most of our drunk driving cases is typically they involve catastrophic injuries. Also, most drunk drivers do not have enough insurance or enough assets to fully compensate their victims for the injuries that have been sustained in the accident. Pretty typical, I get a call from somebody that's been hurt by a drunk driver, and I tell them, look, you don't need me to collect the money from the drunk driver. His insurance company is going to offer you, pay you everything that they have. They don't have enough money in this case, and they're going to write you a check right away. Where we typically help people in this situation is where the drunk driver has been served alcohol by a bar or restaurant. In Oregon, it's illegal and against the law for bars to serve people while they're visibly intoxicated. And a lot of people who are hurt by drunk drivers, they look to the drunk driver to compensate them, and there's not enough money there, and they're forced to look at the bar or they're forced to look at the restaurant. The reason we have that law is to protect people, and this is where the case gets different. In Oregon, bars and restaurants have been given a special protection that nobody else has. And that protection is you can only maintain a lawsuit against them if you provide them notice of your intent to sue within 6 months of the accident if there's been an injury, and within a year of the accident if there's been a death. If you don't send that bar what we call a tort claim notice, you lose all rights. And I get call after call after call where people say, look, I've resolved my case with the drunk driver. I found out later that they were served at a bar, and I want to look to presenting a claim against the bar. And if 6 months have passed, I tell them, look, there's nothing I can do to help you. The other thing that makes these cases different is the burden. We have to prove that the bar served the drunk driver at a time when the drunk driver was visibly intoxicated, meaning we have to go out and we have to find witnesses who were at the bar and observe that person. Many times the criminal investigation against the drunk driver will not look into this aspect of the case. And what that means is that we immediately need to send out our investigators and have them start interviewing people. I'll give you a good example of a case that we had that recently we helped somebody where their son was killed by a drunk driver. That case was Basca v. Old Chicago Pizza. It involved the son of a police officer, and we were contacted right away. We hired an investigator, and it was interesting because the case involved a death. There were actually 3 different investigators who interviewed the same witnesses. There was the district attorney's investigator, the criminal defense attorney's investigator, and our investigator. And out of the 3 investigators, our investigator was the only one who was interested, and he was the only one that found witnesses who could describe what the drunk driver looked at the time that he was served alcohol by the bar. And that's the reason that that case settled, was because we were able to gather that evidence and present it to Old Chicago and say, look, you did violate the law and you made some mistakes that night, and we want you to take responsibility for it, which they did in that case.